state constitution and established case law, prohibits the routine or mandatory shackling of defendants in courtrooms. It mandates that physical restraints, handcuffs, leg irons, belly chains can only be used when a judge makes an individualized, on-the-record finding that such restraints are necessary for security. Ransom-lawfirm.com. +4. Here are the key aspects of the shackle rule in Washington. 1. Constitutional right to be free from restraints. Fundamental principle. The shackle rule, in Washington state, largely derived from Article 1, Section 22 of the Washington State Constitution and established case law, prohibits the routine or mandatory shackling of defendants in courtrooms. It mandates that physical restraints, handcuffs, leg irons, belly chains can only be used when a judge makes an individualized, on-the-record finding that such restraints are necessary for security. Ransom-lawfirm.com. +4. Here are the key aspects of the shackle rule in Washington. 1. Constitutional right to be free from restraints. Fundamental principle. The Washington Supreme Court has ruled that a defendant has the right to appear in court unfettered, as routine shackling undermines the presumption of innocence and impairs the ability to participate in their own defense. The individualized requirement. Courts cannot have a blanket policy of shackling all in-custody defendants. A judge must hold a hearing and find a specific, compelling reason, such as risk of escape or danger to others, before allowing shackles. WashingtonCourts.gov. +4. 2. Scope of the rule. Trials and pretrial proceedings. The protection against routine shackling applies to all stages of court proceedings, including pre-trial hearings, not just in front of a jury. Juveniles. Washington Court Rules JUCR 1.6 generally presume that juveniles appear in court unshackled, requiring a high burden of proof for a judge to order restraints. WashingtonCourts.gov. +2. 3. Key legal precedents. State vs. Jackson 2020. The Washington Supreme Court reaffirmed that shackling without an individualized inquiry violates the state constitution, and placed the burden on the state to prove beyond a reasonable doubt that any improper shackling was harmless. State vs. Williams. Early case law establishing that the binding of the prisoner in irons is a plain violation of the constitutional guarantee, unless absolute necessity exists. WashingtonCourts.gov. +2. 4. Shackling of pregnant inmates. Separate from courtroom procedures, Washington State passed a law, RCW 72.09.651, related to 0.5.2, prohibiting the shackling of incarcerated pregnant individuals during labor, delivery, and postpartum recovery. LegalVoice.org. +1. 5. Exceptions. Shackling is allowed if the court finds it is the least restrictive means to maintain safety. If a defendant has demonstrated violent behavior or a high flight risk, a judge may approve restraints.